Today's topic is going to deal with one of the most common issues that arise in family law legislation. And that's the issue that is of shared parenting and more commonly equal placement issues. And let me explain a bit how it goes. I give you some history and a little bit in terms of my involvement and what my take on it is. There are a number of dad groups, sometimes called Mad Dads, that go up to the legislature every year and have been advocating for a law that mandates equal placement in all or virtually all cases. And I've been through a couple of these hearings years ago when I was involved in legislation, and what the hearings would consist of is some man who looked perfectly fine and spoke perfectly well and told some horrible story about not being able to see his child, and therefore he and whatever group behind him, and I guess there are a couple of different groups that do this, lobby the legislature trying to get a statute passed for equal placement. The history of it starts many, many years ago when traditionally the wife got sole custody. And in fact, it isn't even all that old, because when I started doing family law 30 some years ago, it was fairly typical that unless there was something majorly wrong with the mother, dad got every other weekend and Wednesday evening for dinner. That has changed over the years. I think part of it was changing with the concept with gender equality, and more or less men made the argument, hey, if women are going to be equal in terms of the law requiring that the courts consider their contribution in raising children equal to the man's contribution in making money, then our contribution in terms of raising the children should be equal to the mother's contribution. And with one exception, it's a fairly reasonable argument. And the argument would go that this is what we did during the marriage, is she took care of the kids more, but now that we're not being married anymore, I want to be more involved. And as long as several things are true, there's no reason not to. Or the one thing is geography. It'd be difficult if they're living on opposite sides of the country. The second thing would be the age of the child. As I said, getting back to the one exception where none of this applies is infants, newborns. As I've told guys, when nature allows you to breastfeed, let's talk. But breastfeeding doesn't last forever. A third and major field is domestic violence, which is a major exception to this. And domestic violence is usually man on woman rather than the other way around, and that's a major exception. And then mental illness, drug or substance abuse, things like that can affect it as well. But the male argument was, if we're going to be equal in every other way, in terms of financially, and I can arrange my schedule, and the child's not being breastfed anymore, and there's none of those other issues in terms of geography, domestic violence, substance abuse, or whatever being involved, why shouldn't I have equal time? And the legal system has evolved to the point where the answer is, there's no reason you shouldn't be equally involved if geography allows it. Making the kids get in an airplane every week, you live relatively close to each other, and this is all doable. The legislation has come up in different forms many, many times now, and a number of years ago, it resulted in the statute being amended to its current form, which reads essentially as follows, that in allocating periods of placement, the court should maximize the time with each parent. Well, mathematically, that's impossible, because if you maximize with one, you minimize with the other. But most courts read into it the intent to do equal placement unless any of the circumstances I mentioned earlier are present. And if not, and we're not dealing with a 17-year-old who refuses to go to one parent or another, but in a more typical situation, the court's feeling is gender neutral is gender neutral. And it's actually worked very, very well. A lot of the people that I have come see me in initial consultations have already agreed, or are already, for that matter, dividing the children equally on a placement basis. They may be doing week on, week off, which I'm not real fond of. I've seen month on, month off, which I'm less fond of. A lot of times it's Monday, Tuesday with one, Wednesday, Thursday with the other, whatever, which is a lot of transitions. And the point is, none of the placement schedules are perfect. As a child psychologist who passed away a number of years ago named Mary Zozel, it's a wonderful lady, once told me, the only perfect placement schedule is the parents don't get divorced and the kids come back to the same house every night. If you can't have that, none of them are perfect, but what benefits children in the vast majority of cases is the lack of conflict between the parents. So having a statute that's read by the court as saying that equal placement is preferred but not mandatory, so it leaves the discretion of the court in individual cases to do what the court thinks is appropriate, and 99.9 times if there's a dispute, what the court's going to do is listen to the guardian ad litem. It actually works fairly well, which leads to the question is, why do these divorced dad groups come back every time and request a statute more strongly worded and sometimes mandating equal placement? And a lot of times it comes to due to a term that's called legislation by anecdote. And this happens in our legal system. I've been involved several times in going up to Madison to testify, in lobbying legislatures and talking to legislatures about various issues in family law. Please remember that in the new legislature that's coming into Wisconsin, there are 99 representatives, 33 state senators, total of 132. And I think the count is 13 or 14 have law degrees. And of the 13 or 14, I think only 2 have ever practiced law. So of the 132, about 100 of them, more than 100 of them, don't even have a law degree. And of the 132, about 129 of them, or 130 of them, have never even practiced law. So they don't really have the ability, they don't have the background, they don't have the training, they don't have the education to understand the concepts in terms of what they're doing. And legislation by anecdote, which is listening to someone tell their story and then passing a law based upon that one anecdote, can lead to another problem that sometimes comes up in law, which is known as the law of unintended consequences. And there are numerous examples of this where laws are passed and the consequences of it are something totally different than what was intended. My favorite story about that, it's a whole different continent and a whole different genre, but it at least illustrates the point, was somebody came up with the idea in a village in India that they were overrun by rats, that they were going to pass a law that anybody who came to the village hall or whatever with a dead rat would be paid a stipend. And they would give them a certain amount of money, a certain number of rupees, or whatever it was. And that way they would encourage people to catch rats, bring them in and reduce the rat population. Well, what happened is that some people decided this was a good business opportunity, and they started a business of actually breeding rats so that they could then kill them and then bring them in and make money. And the net effect after a certain period of time was that the law that was passed designed to decrease the rat population ended up increasing the rat population, because when you breed rats, some are going to escape and you end up with more rats out in the wild, and the ones you're buying end up being ones that were created specifically for the point of making money. The point in this, at least, is that the legislature sometimes is guilty of creating the law of unintended consequences. They'll pass law even with good intent that doesn't always operate and work the way in which was intended. And there are numerous other examples of that. I like the rat one because it really, I think, illustrates how these things can have not only not the intended effect, but 180 degrees different. And what worries me in terms of the unintended consequences of statutes proposed by these mad dad groups, these father groups, is that they're based upon anecdotal evidence. And in our system of laws, it's based upon actual life experience. And I'm not saying judges always get it right or judges are always perfect, or for that matter, guardians ad litem are, but there's got to be room that in an individual case, our judges are not handcuffed and required to do something just because in some other case, maybe a miscarriage of justice was done. I don't know if it was or not. I don't know, I'm not commenting on the individual circumstance, but you don't make a law based upon evidence and testimony by a handful of people that are going to affect everybody else. In general, in family law, I've been a huge proponent on allowing the trial court individual discretion in terms of each case has to be weighed on its own merit. And when you come to children, that rule is even more important than anything else. I'm going to be writing on this in my column in the Wisconsin Law Journal, and like to suggest that you take a look at it, and I'll be expounding a little bit further on that in an upcoming issue. And lastly, if you enjoy these podcasts, click on the like and subscribe button at the bottom here, and let me know if you have any comments or any suggestions for future podcasts.